Do you have?
No product that will insure us to pay their cost.
All right. Are there other products that are available to help others who are put in the position when they sign contracts with local agencies that will allow them to have that insurance so that they're not out of pocket when they defend?
Madam Chair, that's outside of my area of expertise, but I do understand just from personal experience that, yes, contractors and subcontractors do have insurance coverage under their general commercial liability, which is separate from professional liability, that covers lawyers such as the members up here.
Maybe Mr. Governor has an answer for that.
Yeah, part of our contract, we have additional insured endorsements, which we'll provide to the owner to cover defense, subcontractor provides to us, so those do exist. As Mr. Urban noted, our policy, premiums will go up as a result. Mr. Urban also noted that they cover the cost at the end up to their insurance limits. The problem that my members have experienced is, in fact, design professionals historically underinsure. Small designers will have perhaps $2 million in coverage, medium 5, large 10 to 20. Conversely, my members, a small commercial contractor will have 25 million, mid 50, large 200 million. So when we go to recover that money at the back end, there's no there. He said to the extent they have assets available, they don't have enough insurance.
Thank you very much. I appreciate the discussion. No, I'm going to ask if there are other members, perhaps that question will come out then. Very good. Senator Wieckowski, followed by Senator Monning.
My question is on the amendments that would allow for the cross-complaint of the design persons. And why is that an inadequate fix? Because it seems to me, yes, for the opposition, because it seems to me ultimately this is a comparative fault problem, the situation. And ultimately you want all the parties, or the parties that we think are at some share of the fault, in front of the court, and determining, presenting their cases and under the American rule, doing their defense. So if this were to become effective and it allows for a cross-complaint, it certainly doesn't prohibit any injured party from suing the design engineers. I mean, there's nothing in here that says you can't sue the design engineers, you go after the city or whoever. Why is that an inadequate fix?
Senator, first off, it's already the case that there are cross complaints. As I said earlier, almost universally, as far as I know, when a tender of defense is tendered to a design professional, they simply ignore it. So a cross complaint is filed, and generally you have 2 layers of litigation then. You've got a lawsuit that proceeds on the substance. Was there negligence or was there not? And then you have a follow-up litigation on the issue of indemnity and defense. So that already exists. I should also add that the language in the proposed amendment that says that design professionals will only have a duty to defend themselves is empty language. There is no duty to defend oneself. The statute that we are concerned about is concerned with the duty to defend others that is associated with an indemnity obligation. There is no requirement, no duty to defend oneself.
The staff report points out that there's a situation where the design engineer could be at zero at fault, found not negligent in anything, but would have paid for the whole litigation. That strikes me as just fundamentally unfair in the judicial system. And regardless of whether it was in the contract or it's 140 years, how do you respond to that?
First off, I've never encountered it in all my years of practice in this area because, as I said earlier, the design professionals simply don't expect it, they do not accept tender of defense. So this first dollar is really an urban myth. It just doesn't happen. And when there is finally a determination on the merits, if there is a judgment that includes the defense costs, those will then be covered by the insurance in most cases.
Senator Monning, followed by Senator Anderson, then Senator Leno.
Thank you. Well, just on that last point for the opponent, the statement that most policies cover the cost to defend. Is that under what type of insurance policy is that? Is it an errors and omissions, or is it a general liability insurance?
Thank you, Senator. That's a great question, and that is one of the things that we're talking about here. With professional liability, unlike the general commercial liability, you do not have an additional insured, and that is because you're insuring against the professionals' errors and omissions. So they're the only ones doing their work, so they're the only ones with errors and omissions. Henceforth, you cannot add an owner, whether private or public, as an additional insured. I'm not an expert in insurance, but I do know that singers get their voices insured, that pitchers get their arms insured, so I'm reasonably confident that with some effort, perhaps with the involvement of the Commissioner of Insurance, it is possible to find a way to cover that uninsured risk.
Thank you. And then still, your statement that the proposed amendment that the design professional shall only have the duty to defend himself or herself from claims that relate to negligence, recklessness, or willful misconduct of the design professional. What I heard you saying is that's currently, they have a right to defend themselves, and if they choose not to, they don't have to.
That's correct.
Okay.
It's empty language.
Thank you. But I do want to hear from the proponent how you respond to that line of questions.
What we're trying to make clear, because we have been accused in the past of evading liability, is we are perfectly prepared, eager, and willing to defend claims against ourselves. We will buy insurance. And let me say parenthetically that every contract we sign specifies how much insurance you buy. So if we're underinsured, it's the entity with whom we contract who tells us how much insurance to buy. But that insurance will defend us. It will not pay the defense costs associated with our client. Right. But I wanted to be absolutely unmistakably clear. We will defend ourselves. We're not trying to evade any liability.
And on that point, is it a legitimate subject of bargaining at the time that contract is negotiated to negotiate what level of liability insurance you might cover, you
Correct.
might have to carry?
And if we can't afford it, then we don't qualify for the bid. If they want $5 million, fine. If they want $10 million, fine. But they should know, and they do know, that that insurance limit does not cover the indemnity. They're independent of each other.
I understand that. Thank you. And a final question, at the risk of being repetitive, because the chair asks this, but for the proponents, are the design professionals the only entity that face this dilemma in these contracts?
It is my understanding, based on 10 years of experience, that yes, in the construction industry, we are the only ones. A lawyer's errors and omissions insurance would have the same limitations if your client is sued and the client tenders it to you. But in the construction world, yes, it's the errors and omissions insurance policy that has this limitation. There's no additional insured coverage. And
but some of the other opponents, and if the author wants to respond to that. Mm-hmm.
And that was why, I'm not sure you were here when I spoke about how I got involved in this. It was a design professional, it was an engineering firm that brought it to my attention when I was on the city council. And at that point, again, not being an attorney, was simply told that's the way it's been for 100 years, that's the way it's been, and if they don't want the job, they don't have to take it.
But for some of these others that spoke in opposition, other contractors, not the public entities, but we heard from subcontractors and others, they seem to think this is a carve-out just for the design professional. Why wouldn't they also be included in this?
it is different treatment because they have the capacity under their general commercial liability policy to purchase an AI coverage, an additional insured, so their client, public entity owner, can become an insured and immediately invoke the policy. We have no capacity to do that. There's no insurance company on the planet that will offer us an additional insured so that we can add Santa Cruz County as an AI. Santa Cruz County could be added as an AI to a contractor or subcontractor's policy. That's the, so yes, it's different treatment, Senator Monning. I don't consider it a carve-out in the sense that it's unwarranted.
Thanks. And then back to the opponents. You described that first provision as empty because it, in the proposed amendments. Are there anything in these proposed amendments that, even if minimally, improve the bill than what you originally reviewed?
The short answer, Senator, no.
Thank you.
Okay, we're making a lot of progress here.
I thought, for the record, they were pretty good amendments.
Thank you. Senator Anderson, you had some questions. And we'll have Senator Anderson, Senator Leno, followed by Senator Morlock.
Thank you, Madam Chair. So I'm sorry for my basic questions, but if I'm the architect or I'm designing it, and the general contractor is being sued, and they're being sued that may bleed over into the work that I've done, why wouldn't I want to have a voice in choosing the attorney that ultimately may be defending the claim against me?
I'm not sure. I apologize.
So if the lawsuit is filed, if somebody else is responsible, you don't always get an attorney who's laser focused on defending everybody. You get an attorney who's focused on defending the person who's paying them. So why wouldn't I want to be at the table in the selection of the attorney? And if I'm not in that process, how do I?
Well, the way it works is if the public entity is sued, they send us the bills. We don't have the capacity to select their counsel. We just pay their bills. If we're sued, our insurance company hires the lawyer and we collaborate on that defense. But if we have to face this tender of indemnity, it's the functional equivalent of being given the bill for the attorney they hire.
Well, except you do get to choose your own attorney.
We get to choose our attorney.
Right.
They get to choose their attorney.
Exactly.
And bill us.
I understand. But they do, you aren't on the hook.
There's two tracks.
Absolutely, yes.
Okay. And then when thinking in terms of solutions for this, you know, many of these small and mid-sized firms, as it's come out in testimony, correct me if I have this wrong, may go defunct over the course of the lawsuit, while at the end of the judgment may not be liable for any of it. But because of the cost, has the industry ever looked at putting a cap on that first dollar of defense and limit the exposure to a reasonable amount to perhaps the cost of the entire project as a proportion to the work done?
It's a superb idea. I call it the thin layer that can be negotiated. That would be uninsured. It would be out of pocket, but my client would be willing to entertain that. But too frequently, it's not negotiable. It's take it or leave it. We would be willing to sit down and talk to people about 1%, whatever the right number is. 1% of the contract is our obligation. At least then we can quantify it. Right now, it's unquantifiable, both uninsurable and unquantifiable, and it's unsustainable. But we actually promoted the idea of what I call the thin layer of defense, but it was not acceptable.
Madam, through the chair, could we ask the other side why that would not be an acceptable approach?
Well, certainly, if you'd like to respond, I mean, we don't necessarily want to negotiate this here, but could you explain? I think maybe the question, Senator, and if you want to ask another one, would be what would be the consequences to the local jurisdiction if there were this thin layer and the local jurisdiction was arguably on the hook to defend themselves because the design architect wasn't going to be required to pick up that cost? Perhaps you could answer both of those.
I'll try to do that. If I follow the thread, the response is this is already happening because design professionals do not accept tender of defense. So public agencies as well as private owners, are already out of pocket for defense costs against lawsuits and claims that are brought against them alleging design defect or other design-related claims. They are already out of pocket for that, and that's what requires the second layer of litigation to resolve that issue.
I think part of the problem is that there's a disagreement on the underlying facts. We had a couple people come in and talk about the money that they had to lay out or that they are aware it was expended, and they had no culpability, but they were out of pocket, a couple $100,000 or more dollars. And what you're saying is that they don't even accept tender of defense.
Correct.
So I think, no. I think that we have a difference of perception on what actually is happening. And maybe that's where we could do something with this legislation to address that they must or they should, and if they don't, then this is what happens. I didn't mean to cut you off, but I'm trying to kind of put us in a more narrow focus so that we can get through with this bill and deal with the other 18 that we have to deal with. So would that be an option?
Madam Chair, I think we are very open to discussions, as we were 6 years ago. We understand this is a difficult issue, and we're not in where we just think there would be better public policy that we could come up with. So that was an excellent suggestion, and we'll look at that and others.
Great. Senator Anderson, you had one more question.
Yeah, well, part of the concerns I have, and I have friends on both sides of this issue, and at the end of the day, I want to build the best public works that we can possibly build at the lowest possible rate to give the taxpayers the highest return. But, you know, we work very hard to include minority businesses, and frequently they aren't the largest of businesses. These are small businesses. And what are the protections moving forward that are provided to those minority businesses who don't have the deep pockets to be able to bid on public works projects because there's no protections for them in these types of situations? And, you know, I don't care I'd like to hear from both sides, but does this have an impact on the number of minority businesses applying for these projects, or are they just not applying?
I think what you heard, Senator, from the testimony, that may well be a consequence of that. But the point is that these are small businesses that are coming to you and perceive a problem, and I'd like to see if we can remedy it and come up with better public policy than we have now.
All right. We have a couple other members who'd like to ask questions. Mr. Governor, did you want to respond to that?
Certainly. We have the same small business issues as do they, which is we see it when it comes to surety bonds, for example. The small minority contractors can't obtain surety bonds. So under this scenario, so long as risk is pushed onto the general contractor, the rates go up, and we have the same difficulty entering the business as would they. So it's, again, it's not a zero-sum game. There are three parties involved here. I just don't want that to be lost.
I don't think it's been lost. That's why we're having this, I think, this dilemma here. Senator Leno?
Just real briefly, Madam Chair, and I may be restating the question that Senator Wieckowski had asked the opposition earlier, but do you believe that there's a better fix to this problem, or that there is no problem to fix? That I think he would use the word urban myth. Is there any injustice here?
As I said earlier, Senator, I am sympathetic to the issue of uninsured risk. I understand that's a real concern, notwithstanding the fact that in real life, the tender of defense is almost always, in my experience, always declined. That said, I appreciate that there is nevertheless legal exposure. And yes, I do believe that a fix is possible. And I believe we can work collaboratively with the proponents to attain that fix. I don't know what it would look like. I think it's important that whatever the fix is closely tethered to Civil Code Section 2778. It has to fit in and connect with existing law. It can't be disconnected. And secondly, it has to be consistent with existing practice and has to explore what the possibilities are for a more surgical fix by finding some insurance mechanism to cover this and distribute the risk.
That's very helpful. Madam Chair, with that said, I'm going to suggest that's the most hopeful thing that we've heard yet. I'm going to move the bill, and certainly you as chairwoman have every opportunity to bring this back if you think this yet to be envisioned or refined solution is at hand. But both sides agree there's something to deal with here, and I think we should give it a chance to be resolved.
Thank you. Yes, as Senator Wojciechowski points out, there's a lot to deal with here. How we do it is really the challenge. So there is a motion, but Senator Morlock, you did have a question or an observation?
Sure, they've almost all been covered. It's certainly a Solomonic issue. Senator Wilk, I want to thank you for taking on a pretty difficult issue. You certainly should get an award for the most witnesses on both sides.
I'm not sure that's a good award.
I don't know if we have any ceremony at the conclusion of session, Madam Chair. But I'm just curious, ACEC, have they ever tried to form an insurance division?
The short answer, yes. It was a spectacular failure. No, it never got launched. There's no capital or insurance company that would entertain it.
Okay, so that when you sign the contract, you say up to the limits of our policy. So, because you said it was unquantifiable.
Our policy defends us. It will not pay to defend our client, and that's the source of the difficulty. They tender the defense to us. We cannot find insurance to pay that cost. If we're sued, which is why I said we'd prefer to be sued than to receive this tender. If we're sued, we have insurance, there's an active and robust defense, and we will pay for any damages for which we're found liable. What we can't insure, and there will never be insurance, is to pay for the costs that our client incurs to defend itself, even in those instances in which there's allegations that we perform poorly. We can't find insurance for that. We have to be sued directly. We'd rather be sued than receive the tender.
But from my understanding, you agree to that when you sign the contract.
That is correct.
So have you ever thought about what the repercussions would be if you just all decided we're not signing any more contracts?
Well, increasingly, people are, and they would tell you that they don't sign them, or as Senator Anderson pointed out, they sign them knowing they're risking the company.
Either that or they don't get it.
So let me ask this question, then I think we're just about done. If this were to be, if this bill were to become law, where does that leave our public works projects? Does this mean the taxpayer is going to end up paying more? Does this mean that a lot of these important projects that heaven knows we need to do in this state with our crumbling infrastructure will not be done? Because that's the other side of the issue here. And I'd like to get a response from both sides. If you'd start the opposition, and then Senator Wilk, if you would include that in your close.
Michelle.
Thank you, Madam Chair. Yes, this is a zero-sum issue. There is only so much public funding available for public infrastructure. The more that public agencies are paying out for defense costs to defend against allegations of design negligence and recklessness, and when those costs are not recoverable, those are public infrastructure dollars that are not being spent on public infrastructure. They're effectively being shifted to the public sector. And I do think that there is a way to resolve this without jeopardizing public funding in that way.
But you don't have an answer now.
I do not, ma'am.
Senator Wilk, would you respond to that and also close, if you would?
First of all, I want to thank the committee for the robust discussion. As I said, when we brought the bill in 2010, we had a comparable discussion, and then the parties got together and resolved some of these issues and was signed by the governor. I think we can do that again. It is not an easy area. I understand that. We are not looking for a carve-out for a particular group. They have said, and I believe completely, that they are not absolving themselves from responsibility for negligence, for recklessness, for anything that comes from their conduct. That's not the issue. So I would ask for the committee's support, and we'll move this forward. And consistent with what the senator suggested, the chair can pull this back at any time, and we'll keep working with you and your staff to make sure that what we come up with meets the standard of the committee.
Well,
Yes
I'm
or
going to
no, I vote-
indicate I have not been clear on what to do on this bill.
I understand.
I will support it with the understanding, first of all, I know we have an author who will act in good faith on this, and I think we've indicated there or demonstrated there should be a fix. I want to be very clear, though, that I don't want to do anything that is going to undermine our ability to do these public works programs that are so critically important, and to do it in a way it must benefit the taxpayer. So with that, and I think I probably am expressing the concern of everybody here, with the ability to bring this back at any point, it does go to the floor next. Did I misspeak, Senator Wojciechowski? No, okay. All right. We have a motion do pass as amended to the Senate floor, with the understanding you will continue to work on this, see if we can find the answer to this, and that we will be able to take it back to return it to committee before it comes back to us on concurrence. All right, with that, Madam Secretary, please call the roll.
The motion is due pass as amended to the Senate floor. Jackson? Aye. Jackson, aye. Morlock? Anderson? Aye. Anderson, aye. Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wojciechowski?
Aye.
Wojciechowski, aye.
Morlock, aye.
Morlock, aye.
Thank you very much.
6-0, that bill is out. Thank you all very much for a very robust discussion.
God bless America. Boy. Yeah. Very interesting. They're going to start by right? That's where we're at. That's where we're at.
Minute, and if the sergeant will let this group out, and if there are people in the hallways who'd like to come in, let's give them a chance to participate.
Support from, but that's industry. Marcher.
All right, we're going to let those who have otherwise been out in the hallways to come on in. We've been able to find some seats.
Be short.